Part 3, motion for reconsideration of Judge Allen's October 27th, 2009 order. On or about February 22nd, 2009, Mrs. Gray filed a joinder complaint and new matter counterclaims against plaintiff/counterclaim defendant Irene Perry with notice to defend. On or about May 4th, 2009, Mrs. Gray filed an amended complaint with notice to defend. On June 8th, 2009, Irene Perry filed a pleading styled plaintiff/counterclaim defendant Irene Perry's motion for summary judgment. On or about October 27th, 2009, the motion for summary judgment was granted. Section number 4 of the Memorandum of Law. Legal argument. Standard for summary judgment. A proper grant of summary judgment depends upon an evidentiary record that either 1. shows the material facts are undisputed, or 2. contains insufficient evidence of facts to make out a prima facie cause of action or defense. McCarthy v. Dan Lepore and Sons, Inc. 724 Atlantic, 2nd Division, 938. Also 940. PA Super 1998. The moving party bears the burden of proving that no genuine issues of material fact exist. Roush, 783, Atlantic 2nd Edition, at 821. The trial court then must view the record in the light most favorable to the non-moving party and resolve all doubts against the moving party. Only when the facts are so clear that reasonable minds cannot differ may a trial court properly enter summary judgment. Opening statement. This honorable court's ruling to grant Irene Perry's motion for summary judgment sends a negative message to all co-tenant landlords in its jurisdiction. The ruling says a tenant by law can choose which of the co-tenant landlords he or she wants to pay rent to over the objection of one of the co-tenant owners of the property. It also says the tenant has the right to determine what the co-tenant owner does with his or her share of the tenant's rent. In the instant action, the tenant, through her counsel, stated that she did not think it was fair for Mrs. Gray to be able to collect 1/3 of her rent and another 1/3 as a garnishee payment to satisfy the judgment Mrs. Gray had against co-tenant owner Ingrid Johnson. In other words, Ms. Perry felt that Mrs. Gray would be getting too much rent. These positions were espoused by Mrs. Perry's counsel at the Rule Returnable hearing October 27, 2009, the assessment of damages hearing against garnishee Irene Perry and Patricia Gray versus Ingrid Johnson, Philadelphia Municipal Court, number S as in Sam, C as in Clarence, -08-08-03-3600, December 8th, 2008. A true and correct copy of the transcript of proceedings of the December 8th, 2008 hearing is appended hereto and incorporated herein by reference at Exhibit A. See page 7, lines 21, 22, 23, 24, and page 9, lines 11, 12, and 13. Ms. Perry's counsel states, Ingrid Johnson pays the taxes, the utilities, and the insurance. This is not the tenant's domain to justify why they are not paying Mrs. Gray her 1/3 share of the rent, because they state Ingrid Johnson maintains the property. Not only is this not the tenant's domain, Miss Perry's facts are incorrect. A visit to the City of Philadelphia's website, PHILA, PHILA.gov, and then put in property search and the address 5400 Mars Street. This will show you that the real estate taxes weren't paid by Ingrid Johnson. Johnson has never paid the taxes. Starkman paid them in 2007, and in 2008 and 2009, the taxes are still outstanding. In addition, Ms. Johnson refuses to provide Mrs. Gray with the keys to the property so that she can allow the state fair plan to examine the property in order to get an insurance quote. Statement of questions involved. Number 1. Did Pennsylvania law permit Patricia Jackson Gray, as a co-tenant owner of 5400 Mars Street, Philadelphia, PA 19131, to demand that Irene Perry pay to Mrs. Gray her share of the rent? Suggested answer is yes. A lease by one of two joint owners with the consent or ratification of the other is the lease of both parties, both owners. Case Windsor versus Raymond and Campbell, 104 PA 33, the year 1883. Plaintiff counterclaim defendant Irene Perry was the lessee of Ingrid Johnson, Gwendolyn Jackson, and Patricia Gray. Notice of defendant/plaintiff Patricia Jackson Gray's ownership of the apartment rented by Irene Perry, and notice that Perry was to remit 1/3 of her monthly rent to Mrs. Gray was given to Irene Perry in the following manner. A. July 28, 2007, letter to Miss Perry giving notice of ownership and instructions to make 1/3 of her monthly rent payments to Mrs. Gray. A true and correct copy of the letter and deed, front page, is appended here too and incorporated herein by reference at Exhibit B. B. September 19, 2007, letter to Miss Perry, second notice to Miss Perry to pay 1/3 of her monthly rent to Mrs. Gray. A true and correct copy of the second letter and deed page is appended here too and incorporated herein by reference at Exhibit C. C. September 27, 2007, letter, certificate of mailing to Miss Perry, third notice to Miss Perry to pay 1/3 of her monthly rent to Mrs. Gray. A true and correct copy of the third letter and deed, front page, is appended here to incorporated herein by reference at Exhibit D. D. January 28, 2008, Miss Perry was served with a